The next statute to discuss is LB566, and that deals with changes to the Indian Child Welfare Act. There is not an emergency clause for these changes, so that means under state law these go into effect after August 29th of 2015. Some of the major changes include the following. First, the court must inquire as to whether any party believes an Indian child is involved in a juvenile court proceeding prior to any rights advisory. So in other words, at the very, very beginning of a case, the court must make that inquiry. The law also states that this state, the state of Nebraska, is committed to protecting the essential tribal relations and the best interest of an Indian child by following federal law. Third thing that these changes do is it does define what are active efforts. Active efforts are defined, and HHS must provide in writing its attempts at active efforts to include that type of level that exceeds reasonable efforts, that are consistent with the Indian tribe's social and cultural conditions. Second, that a request to the tribe and extended family to convene these traditional and customary support and services has been done. Third, that HHS must actively engage in assisting and monitoring the family's access to and progress with culturally appropriate and available resources. Fourth, the identification and provision of information to the Indian child's extended family. So in other words, HHS must give information regarding housing, financial, and transportation assistance for any extended family of an Indian child. They also must identify and make attempts to engage tribal representatives. They must consult with extended family members. And lastly, they must exhaust all available tribally appropriate family preservation alternatives before any Indian child can be placed in out-of-home care. Other changes under LB 566 is a definition of what is extended family. It has its own definition of extended family, and it is defined by each tribe under their tribal law, and it includes a person who is 18 years of age and is also a parent, a grandparent, an aunt or uncle, a clan member, a band member, a sibling, an in-law, a niece or nephew, a cousin, or a step-parent. So it is a very, very broad definition of what is an extended family. LB 566 also codified some of the case law here in Nebraska, where it now clearly defines who is a qualified expert witness that can testify in an Indian Child Welfare Act case. And they have a priority order to it. The first priority is a member of the child's tribe who is knowledgeable on tribal customs. Second order in priority is a member of another tribe who is a qualified expert within that tribe. Third is a lay expert witness that has substantial knowledge in the delivery of child and family services to Indians and extensive knowledge of prevailing cultural standards and child rearing practices within tribes. Fourth, and the last one, is a professional person that has substantial education and experience in the area of their specialty who can show knowledge of tribal customs. LB 566 also clearly states that the tribes shall have the right to intervene in court proceedings regardless of whether or not they have legal counsel. They have the right to fully participate in every court proceeding. It clearly states under LB 566 that prior to the court ordering placement of a child or termination of parental rights for an Indian child, the court must make a determination that active efforts have been provided and or attempted. LB 566 also clarifies what needs to happen in any type of relinquishment or termination proceeding. And what it requires is that the Department of Health and Human Services shall submit information that's specific under the statute to the courts before this relinquishment can happen. This relinquishment must be on the record and must be before a judge in order to be considered valid. LB566 also clearly states the priorities for adoptive placements for an Indian child. First is a member of the child's extended family, based upon the definition that was just given. Second is other members of the child's tribe. Third are other Indian families. Fourth are non-Indian families that have committed to having extended family time and participation in cultural and ceremonial events of the tribe. These priorities also apply to priority for foster care placement. So when you are looking at foster care placement for any Indian child, those are the priorities that the court must find in order to place that child in out-of-home care. Those are the major changes to LB 566 that directly impact the Foster Care Review Office.